We have breaking news. The Supreme Court has made a decision on the first major Second Amendment case in decades.
That's right. This ruling strikes down a New York law that put restrictions on who could get a license to carry a gun outside of the home. The law required people applying for a public carry permit to demonstrate a special need for it. The opinion by Justice Samuel Alito says that requirement is unconstitutional. The ruling was made along ideological lines, with all conservative justices agreeing to loosen gun restrictions.
New York Governor Kathy Hochul tweeted shortly after the opinion was released, saying, quote, "It is outrageous that at a moment of national reckoning on gun violence, the Supreme Court has recklessly struck down a New York law that limits those who can carry a concealed weapon." She also says she is closely reviewing options to keep New Yorkers safe from gun violence.
Meanwhile, New York Republican Representative Elise Stefanik released a statement supporting the ruling, writing the opinion, quote, "correctly declares New York's shameful attempt to shred Second Amendment rights of New Yorkers unconstitutional."
CBS News legal contributor Jessica Levinson and Duke University professor of law Joseph Blocher join us now. Welcome to you both. Jessica, let's start with you. What was the major reasoning behind this decision?
The major reasoning behind the decision, I think, is in some ways the major story behind the decision, which is that the court, in an opinion by Justice Thomas, a 6-3 conservative opinion, says we're talking about a new standard for when we analyze Second Amendment rights. And that standard is we look at the text and we look at history, and we don't look at what is happening right now. We don't look at modern reasons. We don't look at the government purpose today. And so I think the big story is we now know that when you look at the Second Amendment and you're analyzing gun control measures, you're looking at the text, you're looking at the history. This is a vintage Justice Thomas decision. It's a decision that I think he's wanted for a long time. What this means practically is that there are, I believe, 7 states that have laws like New York, and those 7 states will now have to change their laws. It doesn't mean that the Second Amendment is an absolute right. It doesn't mean that we can't put certain restrictions on people's ability to carry concealed carry permits for self-defense outside of the home. It means that New York and other states went too far in light of the new standard that we're using.
So, Joseph, to that point, what does this practically mean for New Yorkers and citizens of other states with those similar laws? Because, as we heard Jessica just say there, it doesn't mean that other restrictions can't be put on gun carrying, correct? So I know a lot of people in New York want to know, what about Times Square? Now that this loosening of the requirement to obtain a concealed carry permit is in place, does that mean that people can come to Times Square with, concealed guns? Or are areas like that that are considered sensitive, can we still have different rules for those areas?
Yeah, I think we're going to see a flurry of legislative and executive regulatory responses in the wake of this opinion. I mean, Jessica's exactly right. It's depending on how you count it, 6, 7, or 8 states have similar laws to New York's. And those are big states. That includes California, New Jersey, Massachusetts, Maryland. You put it together and it's about 1/4 of the American population lives in a state that has a law, a proper cause requirement or good cause requirement like New York's. I think that those states, many of them at least, are going to respond by shifting to a more sort of location-based regime. In other words, if they're not permitted to require people to show good cause for carrying a gun outside the home in the first place, then instead, probably what some of them will do is say, well, this, that, and the other place are gun-free zones. And that, by the way, is something that's perfectly consistent with what the Supreme Court has said in its prior Second Amendment cases and what it reiterates here. That is that certain sensitive places, schools, government buildings, perhaps polling places, legislative assemblies, can all be designated gun-free zones. I think we'll see a lot of activity on that front.
Jessica, this issue of gun control is a highly charged, highly emotional issue, and I wonder what the liberal justices' dissents were to this ruling.
Well, Justice Breyer has a very forceful dissent, and in this dissent, he starts, I think it's the very first line where he says, there are mass killings, where he starts with practically what is happening, which is that there is gun violence. And instead of starting with, here's how we interpret the Second Amendment, He's starting with here's what's happening today and here's what's happening to people's safety. And what we see here, I think, is also kind of a classic division between conservatives saying this is how we read the Constitution. We look at the text, we look at the history at that time, and we really don't look to what happens much after the Second Amendment or the 14th Amendment, because that's what allows the Second Amendment apply to states and localities. We don't look much past that. Then we have the liberals in, again, kind of the quintessential way that they approach the Constitution, saying, no, of course we can look at the modern day. Of course we can look at what are the reasons that New York passed this law? What are the reasons that California passed this law? We don't have to be stuck 100, 200 years ago when we're interpreting the Constitution. And I think it's exactly right that the fight now moves. So now we know that these shall issue states, where public officials have some discretion as to whether or not to grant a concealed carry permit, that those will now move, and we'll talk about more geographic specific, these sensitive area issues. I think that's the new kind of front where we're going to fight, but certainly this doesn't answer every Second Amendment question.
Well, Jessica, that could be what New York Governor Kathy Hochul is referencing, because she tweeted after the opinion came down, she called the decision reckless and saying she is closely reviewing her options. So, Joseph, my understanding is she's probably going to be reviewing some of these potential options, like we've just discussed, location-specific rules to keep some of these stricter gun laws in place. Does this ruling leave space for that?
I think it probably does. And I think it's worth noting that, gun regulations come in all kinds of shapes and forms. Some target particular classes of weapons, some target particular classes of persons. And this opinion has nothing directly to say about those. In fact, Justice Kavanaugh, in his concurring opinion, which is very interesting, he and the Chief Justice entered a concurring opinion, meaning they agree with the majority, but wanted to say something a little more. But because they were essential votes to getting the majority, what they say in the concurrence really, really matters. They say these are the conditions, basically, of us joining. And they reiterate what the Supreme Court said in its opinion by Justice Scalia in the 2008 decision in District of Columbia versus Heller, which is that nothing in our opinion should cast doubt on such longstanding regulations as those on people convicted of felonies, people adjudicated mentally ill, dangerous and unusual weapons, and concealed carrying itself. So I think there's still a lot of regulatory authority. This is a case really about carrying guns in public, what gun rights advocates would just call the right to bear guns, as in distinction, for example, the right to keeping them, having them in your home. And so in some respects, it can be read pretty narrowly to just say there is a right that extends outside the home, and that, as the court puts it here, law-abiding people get to do that without first having to convince a licensing official that they've got especially good reason to do it.
But Joseph, really quickly, that is an interpretation of the Constitution, correct? Because the Constitution doesn't say you have a right to bear arms in or outside of the house, right?
That's exactly right. And in fact, until now, the Supreme Court has clearly spoken to that.
Sorry, Jessica, you wanted to say something as well.
No, I apologize. I thought that one was to me, but that's exactly right. This is an interpretation issue. We're following up on Heller, which talked about the right to have weapons inside the home for self-defense. And now we're following out those threads. What are the next questions? I think it's so important to emphasize what you just said, which is these key concurring opinions, the Chief Justice, Justice Kavanaugh, saying, we're not talking about other things. We're just talking about New York's law, their concealed carry permit law, and the fact that it has all of this discretion and this heightened standard that applicants have to show in order to get a gun that you can carry outside the home.
So, Jessica, if that is the case, and we are to look at this sort of narrowly, as you and Joseph has just described, what could the potential ramifications be for other kind of gun control proposals that we know have been debated on Capitol Hill? Things like age restrictions to assault weapons bans, limiting high-capacity magazines. I mean, what could the potential implications be down the road?
So I'm going to give kind of a strange answer, which is in some ways this case doesn't address that at all, meaning in some ways this is just about this New York law and maybe 7 or 8 other states that have similar laws. In other ways, it absolutely addresses those separate, bigger questions because it tells us, and I'll go back to what I started with, because it tells us the standard we use, because it tells us text and history, because it tells us we don't look to the reasons why the federal government or states are passing those laws today. We look at whether or not it would have been permissible when the Second Amendment was ratified, when the 14th Amendment was ratified. So it doesn't specifically address it, but the new legal framework does tell us how we'll analyze those new proposed restrictions.
Interesting stuff. Thank you so much, Jessica Levinson and Joseph Blocher. We really appreciate your insight.